This is Dr. David Shine, and welcome to Business Law 101. Normally, assignment is okay, but suppose the contract is this. You're the new contract for a pro football team. You're the new quarterback. You have a $40 million 4-year deal. You may not, and I usually do this live in the classroom. It's more fun. So I pick out some big fellow who looks like he could play football, even if he's not a football player. And I say, hey, so suppose they came down and they offered you $1 million to show up for spring practice and go out there. And of course, a person without substantial training is liable to be DOA in about 15 minutes out there on a pro football practice round. But in any event, so the person says, hey, I got $40 million. I want to ride around in my Rolls Royce. I don't want to get smashed and get my pretty face broken and all that. So I think I'll send you over there and I'll give you $1 million. I'm not going to give you 40 million. So the substitute shows up for spring training with the football team. And the football team says, no. Doesn't work that way. You personally, you star quarterback, you must be the one who shows up and does this deal. We're not going to pay anybody else. So it's a pretty interesting area, but that's where you may need a consent where there's a unique or important service being provided. And the parties that are involved may say, we have a right to control to whom this contract is assigned. Now, you could assign part of the money. The young football player may say, I'll give 20,000 of this to a real estate investment trust that I have so that I can increase those monies. And they may do that, but that's a little bit different situation. And keep in mind, in terms of performance, the assigner must still perform. So if the assignee performs, then good. But if the assignee does not perform, the assigner is still on the hook for that level of responsibility. This is Dr. David D. Shine for Business Law 101. If you've enjoyed this episode, please subscribe on your favorite platform.